All right, folks, we're now joined by Malike Kellier, who is the Acting Deputy Director of Public Prosecutions. He's here with us to talk so many things. I suspect there are so many things that he can't speak.
Yes.
Good morning and welcome to Smile. How are you?
Good morning. I'm well. Thank you for having me.
I think we're having this because of what we heard recently, and I know it's still in the court, so I suspect that you can't speak specifically to certain things, but there was a murder charge, and he says, no, I didn't kill the person, manslaughter. What's the difference with a manslaughter and murder? Like how many years you'd get for murder as opposed to how many years you can get for manslaughter?
But also, what constitutes manslaughter versus murder?
Yeah.
How we know there are nuances.
Yes, beautiful question. So murder is for want of a better term, the larger offense, and manslaughter is the lesser offense. And in order to be pleaded to manslaughter, the lesser offense, you must engage in some sort of defense, whether it is provocation or self-defense or diminished responsibility. So once one of those defenses occur, then you may be obliged to plead to manslaughter, which is the lesser offense. The sentencing guidelines, which was promulgated in about 2017, gives us ranges for sentences. And the sentencing guidelines really helps to provide some sort of consistency when we think about sentencing generally. And so because manslaughter is a lesser offense, certainly, therefore, a lesser sentence would be inured to one who has pleaded to manslaughter in contrast to murder.
So murder is intentionality?
Intention to cause...
Premeditation?
It can be, but it can also be, once there's the intention to cause really serious harm resulting in death, that is murder. But if you put into play now defenses such as I say, provocation or diminished responsibility, which is some sort of snap, or also self-defense, then you may have the defense of manslaughter available to you.
So, if I'm charged for murder...
if someone is charged for murder, not you.
Well,
just say someone.
Yeah.
Thanks.
So he's charged for murder. I was reading, and your office said the reason that they went with the manslaughter charge or whatever is because they couldn't prove that he was lying when he said that he was provoked. So if he didn't, or because I don't want to be specific, but if the person did not plead guilty to manslaughter, but said, I am not guilty of murder, period, how would you prove that if you're suggesting that you couldn't prove that he was telling a lie?
Well, as I understand your hypothetical question to be saying, you have to, again, when you are assessing a file, look at all of the circumstances that you have on the file and all of the information that you have on the file to prove the offense. So as you're saying, Simone, if there's the intentionality, if you have the relevant details to prove the offense, then that is what you put up. And so when we go through files or case files, those are the things you look for in terms of determining which route to take. Nevertheless, remember, apart from a person being arraigned, they have to go through a trial process. So it is, again, up to the Tribunal of Law and Fact, judge and jury empaneled, if it is a judge and jury matter, or the judge alone, if it's a matter that the judge sits alone, to determine, based on what they have heard, what the verdict will be.
Talk through diminished responsibility for me.
So diminished responsibility has to do with the mind, specifically. So, for example, you have insanity, which is one end of the spectrum, and you have diminished responsibility. In those circumstances, specifically as I mentioned, defenses, it is on the defendant to prove what their position is. So we are saying specifically, for example, the offense is murder. What is your defense? You have to now prove why it is, for example, with diminished responsibility, what is the disease of the mind you're suffering with, a temporary or otherwise.
So that could be like temporary loss of your faculties or...
So therefore, you'd have to bring the medical evidence now to confirm this is the position.
Wow, wow. Provocation as a defense, I find fascinating.
It can be.
Because people who plead guilty to murder or who are found guilty of murder are oftentimes provoked. Well, rightfully or no, how do you... is it the first time ever? How do you argue provocation as a defense?
Well, that's for the defendant to argue, not necessarily the Crown to argue. So the Crown will put up its case, and you'll have to now negative and show why it is specifically you say you're provoked within the confines of the law. So there is a distinction between how we understand the provocation in the public domain or general situations versus...
None of Wally Puffers get provoked every day. And we don't
if, for example, there's a cooling off period, you can't say you're provoked.
Yeah. And what's the difference between, because again I'm reading, what's the difference between being provoked and acting in self-defense?
So self-defense specifically is if there is a challenge to your life or property and you're defending same, then that is self-defense. In contrast to provocation, there must be some instantaneous act which allowed you to respond. There was no cooling off period. So you can't come and say you were provoked and the argument finished and you went away and came back.
Or you had time to collect yourself.
Collect yourself.
Malike, tell us about the plea bargaining part of all of this. What if I was charged for murder and I pleaded guilty? In other words, instead I'll go to court and the court find me guilty, but I put up my hand and say I'm guilty. What would be the difference there in terms of sentencing because I plead guilty?
Well, you mentioned two things just now.
Yeah.
Plea bargaining generally is the Crown and Defense can engage in discussions to determine sentence. And that can also be aligned with the sentencing guidelines, as I mentioned before. So the sentencing guidelines provide a consistent framework that can be utilized by judges, by persons who are also engaged in the criminal justice system to look at consistent what are the range of sentencing, aggravating, mitigating factors. If the person has been in custody, what are their background to assist in coming up with a sentence that can help reduce trial time, etc.
And plea bargaining has to be mutually agreed.
Correct.
By both sides.
By both sides. So they can use the sentencing guidelines to as well guide them in terms of what the determinate sentence will be. So you have those guidelines which are generally provided to assist all stakeholders, provide some sort of consistency in terms of the sentencing process. So you don't feel like you get the sentence or you get the sentence and there's a disjoint between the two.
Mr. Alexander Shaw, attorney at law, has joined us. Morning, sir.
Morning.
Welcome to Smile, Simona. Simona, never with you. Just before we go to Alexander, I don't know if I got the answer as opposed to
plea bargaining and something else.
As opposed to if he was found guilty and did not plea, but he was found guilty. What's the difference if he did plea and say I am guilty? What's the difference with it?
So with being found guilty versus pleading and just you will get a discount specifically.
Yeah.
So if you plead guilty, you have the Criminal Justice Administration Act, which allows for persons to get discounts at varying times, whether before a trial, during a trial, or way before at the first relevant date or first before the court date. This is in contrast now if you would have utilized judicial time to go through the trial process, then the sentencing would have been different.
And how is that discount measured?
So the legislation gives you certain percentages, and there's a discretion in terms of the judges having, for example, up to. So legislation may say, for example, if it's the first relevant date, up to 50%. So it must not be 50, but it can be up to determinative of various circumstances that are available.
Yeah. Sir Alex, I hope them don't think it's Alex Ferguson when I say Sir Alex, but I said at the top that we're having this discussion because of what we heard recently with Mr. Silvera. It's still in the courts. I don't know how much you could say about it, but are you surprised of what has gone on so far in this case?
Well, absolutely not. I think Malike explained earlier, because once there is an element of provocation, then it doesn't matter whether it's raised before, the judge is bound to consider it. And so if he's asserting that he was provoked, it's because of some provocative words or actions why he acted the way he acted, then I can't see how it would have gone differently, or how things would have been differently. So I'm not surprised.
I asked a question earlier that the office of the DPP said one of the reasons they accepted the manslaughter deal was because they could not prove that he was lying when he said he was provoked. So my question is, how could you prove if him say never kill her, period? How would you prove that?
Well, I think the evidence on a whole is supporting a killing, and the autopsy, I'm assuming, based on the statement that was published, even with respect to the gun that was used, it's hard to deny that there was a killing, because there is in fact a killing, and all clues, all the puzzles are pointing in his direction. In terms of how it happened is the difficulty that the Crown faces, because there's no eyewitnesses to say, well, this is what happened. We know what happened, we just can't prove how it happened. And so in a situation like that, where he's saying, well, yes, I killed her, but it is because I was provoked, or it was because of a sudden loss of self-control, then it's really hard to rebut that argument.
Oh my. I have so many questions.
Yeah.
I can't ask none of them. Because I know what I'm going to be told, but perhaps when the matter is out of the court, then we can, ask more, get more answers. This case is straight out of a Lifetime movie.
But
Yes,
I tell you what, though.
Quickly, because we have to go.
There are some.
Yeah, go.
There are some jurisdictions, though, where words cannot amount to provocation. And perhaps that is where we should go, if it is that we believe that, there is nothing that should be said to cause one to react or to kill someone and then get away on a manslaughter charge. So.
Okay, hear that. Malike wanted to say something else before we go.
Just to, educate or inform our viewers and listeners that, the sentencing guidelines and plea negotiation and agreements are there to assist the courts as best as possible with the efficient disposal of matters. It allows all parties to be a part of the process, and I think that's what's critical, even leaving this discussion, that we have these laws in place to assist each and every one of us in the criminal justice system to advance the cause of justice, but to also allow even the public to appreciate or understand more about how sentencing goes.
How often do we review those guidelines to make sure they're still...
So the sentencing guidelines was promulgated in about 2018, and there is a provision that it should be reviewed soon, and the Plea Negotiations Act around the same time. So it could be up for review anytime now.
Alex, another question I asked before you came was about not provocation, but self-defense, because he also said he was slapped. Well, that's what I read. I read that he said he was slapped. So could he not argue I was defending myself?
That would have been very difficult to argue, because a slap, gunshot, responding with a gun is not commensurate, right? So your response must be reasonable, must be commensurate. So if I slap you and then you pull a gun at me and then kill me, no. So self-defense would have failed. And the best defense then has to be provocation, because a defendant usually try to use both self-defense and provocation, but then that reasonableness of force is always a challenge.
Okay.
Interesting.
All right. As Sim said.
Show Jinx, more on. More on, folks. More on. Gentlemen, thank you very well.
Thanks, my friend. Stay safe.
By both of you. That's why you do what you do. Malike Kellier, Acting Deputy Director of Public Prosecutions, and Alexander Shaw, Attorney at Law. Take a break. Coming up.
Yeah, the National Secondary Students' Council joins us to explain why Jamaica needs a formalized mental health policy for students. Stay with us, please. Soon come.